HB19 by Leach relating to procedure, evidence, and remedies in civil actions.
The chair recognizes Mr. Leach to explain the bill.
Thank you, Mr. Speaker. Members, appreciate your patience today as we've been working through the final details on House Bill 19. Members, it's my pleasure to lay this bill out to you today. I'm going to try to be brief and to the point, but I do want to explain why we filed this bill, what the bill does, and then we've got just a couple of amendments. At the outset, I do want to thank the many stakeholders, experts, attorneys, citizens, and legislators, many of you, namely the members of the House Committee on Judiciary and Civil Jurisprudence who've worked so diligently to improve and strengthen and perfect this important bill. Members, this bill before us today, House Bill 19, the committee sub to House Bill 19, is the result of countless hours of communication, listening, deliberating, and wrestling together with an important issue relating to our civil justice system. I'm very confident, members, that this bill that's in front of you today represents strong, sensible, and common sense public policy that we should all be confident and comfortable in supporting. Members, you're going to hear some legal jargon today, although I'm going to try to keep it to a minimum, but I just want to be very simple about what this bill does. This bill is designed to address not just a possible or a potential threat. This bill is meant to address a very real and present threat to our state's economy. This is a problem that exists right here, right now, and the legislature has an opportunity with House Bill 19 to address it and to address it in a real and meaningful way. Members, at its core, this bill is about justice and fairness in our courts. I want to be very clear, members, about something that maybe some of you have been misinformed on, but as the author of the bill and as your colleague, I want to make something very, very clear to this body. I can unequivocally state and commit to you that this bill that's in front of you today provides full protections for any injured Texan, for every injured Texan, actually, who's in an accident with a commercial motor vehicle on a Texas roadway. This allows every and any injured Texan to be made whole and to seek justice from drivers of commercial vehicles and from the employers who send them out onto our roadways. So despite what you might have heard, the bill ensures that full protection for those injured Texans and families. The bill also ensures that negligent drivers and the companies that employ them will be held liable for accidents that they cause. At the same time, this bill installs a legal and procedural framework that will protect Texas businesses of all sizes from abuses in our justice system, from abusive lawsuits that are threatening the very existence of many of our small businesses. The facts are very clear, members. As a result of an abusive lawsuit environment in Texas and many nuclear verdicts that we're seeing across the state, commercial vehicle insurance is skyrocketing, and it's becoming unaffordable, unattainable for many Texas companies and employers. Owners and operators of commercial vehicles in Texas are simply dealing with an unsustainable lawsuit environment, and we've got to fix it. In closing, I want to make sure you also know that this is not just about big trucking companies. That's what you see on billboards. That's what you see in TV ads. Those are the images you've seen that have been placed on your desk and brought to your offices. But get this, that 90% of commercial vehicle owners in Texas have less than 10 trucks. Most are mom and pop businesses. Most are small businesses. It's your local plumber, your local landscaping company, your nursery that has a delivery service, your your favorite restaurant that delivers. Any commercial vehicle, not just the big 18-wheelers, but any vehicle in this state that's a commercial vehicle is affected by this bill. And so, members, that's why over 500 businesses across the state have supported House Bill 19, are supporting House Bill 19. Businesses of all sizes, major trade associations, folks you and I know and regularly work with, they see this problem and they believe that the committee substitute to House Bill 19 is the answer to the problem. And so, again, I want to thank you, members, for your work, your diligence, your input in working to perfect this bill. I know right now I'm the only thing standing in between you and dinner. And so hopefully I've outlined what the problem is to you. I'm happy to get into the details of the bill. And I'm happy to take questions. I would appreciate your favorable consideration on the bill.
Mr. Speaker, will the gentleman yield for questions?
Gentleman yield for questions.
Yes.
Gentleman yields.
Thank you, Representative Leach. I'd like to follow up on that invitation you just made, just to talk a little bit about some of the areas of the bill, maybe a few that have received a little bit less attention than others. But one thing I understand about this bill is that it says that an employer defendant is entitled to make certain stipulations. And if they do make those stipulations, and this is in Section 72054, if they make those stipulations, their liability for certain kinds of negligence claims will be limited to respondeat superior liability, correct?
That is correct.
And so, if I understand correctly, they gain a benefit, in essence, by limiting their liability if they make those stipulations. Is that correct?
I would not put it that way, no.
I'm sorry?
I would not put it that way, that the company's liability is limited under this bill. What this bill does provides a judicial framework, judicial management of the case if the defendant elects, whereby there will be two phases to the trial, a bifurcated trial. The first phase will actually be about the accident under a negligence standard, and then the second phase, if necessary, could be about more than that. So that's what this bill in essence does, but I don't think in any way it limits the ability of Texans to hold companies liable and responsible under Texas law.
Well, and what I'm getting at, if we look, if you have the bill, I'm on page 5 of the bill. At the bottom of page 5, where it starts with 72.054A, it says, in a civil action under this subchapter, an employer defendant's liability for damages caused by, and then just to skip down a little bit.
Well, Representative, don't skip down too fast, because the next few words are the key words, key operative words in that section.
Okay, well, let's go through them. That's fine, Representative. So, an employer defendant's liability for damages caused by the ordinary negligence of a person operating the defendant's commercial motor vehicle shall be based only on respondeat superior if the defendant stipulates. And then it goes on to talk about what the stipulations are, correct?
That's only half correct. The defendants in the first phase, the defendant's liability under an ordinary negligence standard, Representative, is limited to respondeat superior. Now, we are going to have an amendment that's going to subsequently follow, and I think that will clear up some of what you're talking about, but there's no question that the accident will be in the first phase, and then any claims of direct claims against that defendant employer, say for hiring, training, supervision, would be under a gross negligence standard in the second phase of the trial.
Okay, so the stipulations that we're talking about are listed on the next page, correct? They would stipulate that the person operating the vehicle was the defendant's employee and was acting within the scope of employment, correct?
That is traditional respondeat superior law, yes.
Now, there can be cases, obviously, in which an employee who's driving a company vehicle might be doing so outside the scope and course of employment. Do you agree?
That's correct, yes.
Right. Such as if they took a detour from their assigned route and they went to go visit their favorite restaurant or something like that. Something that was not authorized, not in the course and scope, correct?
That can happen and would be a fact issue, but that can happen.
The question I have is there anything in the bill that would prohibit a company from stipulating that the driver was acting within the course and scope of employment when in reality the driver was not?
Representative, if you could restate your question before I answer,
Sure.
I just want to make sure that I'm understanding exactly what you're asking.
Yes, so I'm trying to figure out, is there anything in the bill that would prohibit or prevent an employer defendant from making the stipulation that the driver was acting within the course and scope of employment when in reality the facts might show that the driver was not acting within the course and scope of employment?
Well, the stipulation here to respondeat superior that in the course and scope of employment and that the defendant, the driver, was actually the employer's employee, as opposed to someone who might have stolen the commercial vehicle and was not the defendant's employee, that's only relating to the election of the bifurcation here. So if you stipulate respondeat superior liability here, the employer would then, that is a condition precedent, if you will, a prerequisite to opting into the bifurcation, which is what this bill provides for.
And I guess what I'm driving at there is, let's say an employer defendant finds it desirable to opt into the bifurcation and to have the limitation on ordinary negligence liability that is provided here, when in reality the facts might show that the driver was acting outside the course and scope of employment, but that nonetheless the employer wants the benefit of this protection and therefore makes that stipulation. Is there anything in the bill that would prevent an employer defendant from doing that?
The bill doesn't speak to traditional respondeat superior law. That is simply this bill is providing a judicial framework, judicial management of the case. So I don't believe that this bill speaks to your specific question.
So as far as we can tell, there's nothing that would stop such a stipulation from happening. And I know, as you're an attorney as well, as am I, sometimes parties will stipulate to facts, or stipulate to an issue in one way or another, and the court doesn't typically do an independent inquiry into that stipulation. That's usually how it works.
This bill is limited to the situation, is meant to address, Representative Turner, the situation in which a defendant employer is stipulating that that the employee was the defendant's employee and is acting within the course and scope of his employment and therefore elects the bifurcation. That's what this bill is dealing with.
Let me, if I can, shift to the previous section of the bill, 72.053. This is the one that involves the possible failure to comply with, quote, regulations and standards. You follow which section I'm in now?
Yes.
Now, if I understand correctly, under the bill, the jury would only hear evidence of a failure to comply with regulations or standards in phase one of the trial if certain conditions are satisfied, correct?
Correct.
And the regulation or standard is a defined term in Section A of 72.053, correct?
That is correct.
And just so the body can follow along here, it says in this section, regulation or standard includes a statute, regulation, rule, or order regulating equipment or conduct adopted or promulgated by the federal government, a state government, a local government, or a governmental agency or authority, correct?
Yes.
But it does not attempt to list out those specific statutes and regulations or rules here in the bill. Is that right?
No.
And, okay, so I'm now leading to
the text says what the text says, Representative Turner.
Right. And so the question I would have is, how would you say the parties are going to be able to determine which regulations or standards we are talking about here?
Well, if a driver runs a red light, I think we're fairly certain what regulation or standard was violated. If a driver speeds and causes an accident, I think we're fairly certain what regulation or standard or rule or law was violated. That's the purpose here is for that regulation or standard, if it's approximate cause of the accident, can be brought up in the first phase of the trial. I don't think there's any question about, in that case, what's going to...
Right. Are you comfortable that parties would be able to determine which regulations and standards existing in federal law, local government law, state law would apply here?
When it comes to the actual accident, and the purpose of this bifurcation, let me be very clear, Representative, is to, and I appreciate your questions. I think they're good questions and reasonable, but this is about the first phase is the accident. What caused the accident, who caused the accident, what damages did the accident cause, what compensatory damages should be awarded, and then the second phase is then about was there on the employee or defendant's part, the company's part, were they grossly negligent in hiring and training and supervising? And so what we want to do by way of this bill is make sure that the jury's attention is brought to the actual accident itself. And so if there's a regulation or standard that is actually approximate cause of the accident itself, that's going to be brought up in the first phase of the trial. And I'm fairly certain that our attorneys on both sides of the bar and our judges across the state are going to be able to ascertain, like they do normally in current trials, what regulations or standards were actually violated.
Okay. Thank you for answering my questions.
Thank you, Representative.
Yeah.
Mr. Raymond, for what purpose?
Parliamentary inquiry.
Please state your inquiry.
How much time does Chairman Leach have left in his opening?
He has about 6 minutes.
6 minutes?
Plus or minus.
Thank you. Ms. Speaker?
Mr. Raymond,
with the gentleman yield for a couple of questions.
Gentleman yield for questions.
I'm happy to. Yes.
Okay. Thank you. So, Chairman Leach, let me ask a little bit. This is an issue that I've been approached by a lot of folks from my district in Laredo. You know, we have a lot of trucks in Laredo, a lot of trucking industry because of our trade with Mexico in particular, and so I have a great interest in it. And I want to ask you if you can sort of, I know you talked a little bit in your opening about that you've been working on this, continuing to work on this bill during the day. Is that correct? And I think you have there's some amendments coming?
That's correct, yes.
So the big thing that I get from Laredo is this. I'm talking about from the actual businesses, people that own trucking companies, not so much from bankers and others who aren't as familiar with the business. But the big focus is cost of insurance, right? Insurance rates going up. And their thought is we need to do something to bring insurance rates down. You've heard that, right?
There is widespread concern about skyrocketing insurance rates,
right.
Yes.
And so what I've told them is I very much want to help them. I'm not on this committee. I was on this committee for 10 years. I wish I was in it now. If I could be on 3 committees, I'd be on this one if the Speaker let me. But I want to ask you, when you were continuing to work on this bill, will there be provisions put into this bill that are going to assure that insurance rates are going to go down?
So it's a great question, and there's no question that a main motivation in this bill, not the only motivation, but a main motivation is the very real and serious concerns about the affordability of commercial vehicle insurance. And it's not just the trucking companies in Laredo, it's businesses of all sizes who, Representative, have no accident history whatsoever. In some cases, folks are, over the past 4 to 6 years, are paying 100% more without any accident history, and a large part of that is due to the abusive lawsuit environment. So can I guarantee and ensure by way of this bill, can we manipulate insurance costs in this body? I don't believe we can control or do that. That's not what this bill's meant to do. Do I believe this is going to have a major, meaningful effect? Yes, I do. And in fact, Representative Smithy has an amendment that's coming up that will actually, I'm going to let him talk about it, but will ask TDI, require TDI to do a study.
My understanding that Chairman Smithy's bill is going to be simply a study, and we'll talk about that because he referred to a past effort or studies that we've asked of TDI that weren't very effective. So I'm asking you, because I do believe, by the way, I believe that if we wanted to, we could assure that insurance rates go down. And I'm asking you because this is a very important, maybe not to other members, I don't know, I can't speak for others, but for me, it is super, super important because that is the issue for us in Laredo. That is the issue for my truck. If we're going to do something, we need to guarantee, and with all due respect, Chairman, we can guarantee insurance rates going down if we put it into this bill. That is a fact. We can guarantee it. We can pass a law. And if we're going to pass a law like this and do some of the things that you want to do, we need to guarantee insurance, in my view, and the view of a lot of the people from Laredo that are interested in this, because otherwise, you know, I mean, that's a big issue.
We actually don't directly regulate insurance rates in Texas.
We can.
Well, I respectfully disagree, but let me restate what I said, or maybe put it a stronger way. I believe strongly and sincerely that, and there's a lot of other folks who believe the same thing, that with passage of this bill, we will see commercial vehicle insurance rates fall in this state.
If we will, then let's guarantee that,
I believe that the
Leach.
bill written as is, and there's people a lot smarter than me who've been doing this a lot longer than me who agree that with the framework that we're putting in place with the bill as is, it will have a major and meaningful impact on the commercial vehicle insurance rate market across Texas.
Let me ask you this. Let's just assume for the purposes of the discussion that they're off on that, because we've had other experiences like MedMal and all, and insurance rates didn't go down. We passed significant reforms. And you've heard the saying, fool me once, shame on you, fool me twice, shame on me. You've heard that, right?
I have, but I've also talked to doctors in this very chamber, Representative, who
let me ask you,
who reaped the benefits of the passage of those laws in their med-mal insurance.
So let me ask you,
those bills did have a very real impact on the affordability of insurance.
So let me ask you, if in fact, let's say this bill passed, Chairman, in the form that you wanted it to pass, and we see with time that the insurance rates not only didn't go down, but actually went up. Would you feel bad about that?
No. I mean, my hope is that they will fall. But
you wouldn't feel bad if they went up?
My hope is that they will fall, but I'll never apologize or feel bad about providing more justice and fairness and a level playing field in our courts all across this state, whether it's on commercial vehicle lawsuits or otherwise. And that's what this bill is meant to do.
Well, with all due respect, Chairman, I think that we ought to consider maybe a sunset on this bill so we can either it's proved up or it isn't. So you feel confident and others feel confident that insurance rates are going to drop. Let's put a sunset on it, because when that sunset is up, if it's going well, if you're still here, will pass another bill, or someone else will. We'll all be for it at that point.
I would agree to 100 years
sunset. If it goes the other way, Chairman, if it goes the other way, then you feel like the other side was dealing in bad faith.
No, I don't think that at all. That's not what I don't think I've said that. That's certainly not what I'm implying. I think that this bill, I have full confidence. Representative, this is the first you and I've spoken about this bill, but we've been working on this bill for many months, and there's been attorneys and experts who've opined on this bill, and they believe that it's carefully crafted to have a positive impact on the commercial vehicle insurance rate. That's why so many businesses,
Chairman,
Representative, over 550 businesses are supporting this bill.
Mr. Speaker, I can't hear.
I can't either.
The gentleman's time has expired.
Thank you, Representative.
Time has expired.
Gentleman's time has expired. Following amendment, the clerk will read the amendment.
Amendment by Leach.
The chair recognizes Mr. Leach to explain the amendment.
Thank you, Mr. Speaker. Members, this floor amendment number 1 is a perfecting amendment. After the committee substitute was voted out of our Judiciary and Civil Jurisprudence Committee, many members in this chamber and various stakeholders pointed out a few technical problems with the bill. This amendment addresses those technical issues. I don't want to go through it in great detail. It should be on your screens in front of you. But, for example, we changed the word A to the in a couple of places. We made clear that the law is not talking about any accident, but the accident that is the subject of the lawsuit. There's several other minor wording changes. In addition, I will mention this. The committee substitute exempted passengers in buses from the bill. This amendment exempts all passengers in a commercial vehicle except employees of the company that own or operate the vehicle. So we believe there was another amendment that allowed a defendant to file a motion to bifurcate the trial within 120 days after filing the answer. That created the ability for gamesmanship, and we removed that as well. So, members, I move adoption of floor amendment number 1.
The following amendment to the amendment.
Amendment by Lucio.
The chair recognizes Mr. Lucio to explain the amendment to the amendment.
Thank you, Mr. Speaker. Members, so in this bifurcated trial structure, one of the things I was concerned with, that in phase 1 of that bifurcated trial, in the circumstances where the employer defendant did not act responsibly, that the jury would get to consider, evidence would be presented that they did not meet basic common sense public safety standards. That was what I brought to the stakeholders and brought to the chairman for consideration. And to his credit, he listened. But we wanted to root that prudent operator standard in something that could be consistently applied in every jurisdiction, in every case. So what we decided to do was root that in federal and state law. So in the phase 1 of the trial, as the bill is written, all that is considered is the defendant driver's negligence. My amendment would allow for consideration of the employer defendant's negligence. And we enumerated over 5.5 hours of review specific sections in transportation code that made sense, that we thought was good public policy and public safety standards in order for that consideration to take place. So now with my amendment, negligence or responsibility can be allocated in phase 1 of the trial to the employer defendant. And I think that that is very responsible. Couple things. We also added a September 1st effective date. And we added and made sure that my amendment applied both to intrastate and interstate commerce or operators. So if you take truckloads from Brownsville, Texas to Dallas, this amendment will make use subject to this bill, even if you don't cross state lines. So, I want to thank Chairman Leach for listening and sitting down and going over every one of these transportation code to make sure that we pick those that are truly representative of prudent operators. And I believe it's acceptable to the author. I want to thank everyone. There was many of you in this room that helped. Thank you.
Mr. Lucio sent an amendment. The amendment is acceptable to the author. The objection to the adoption of the amendment to the amendment. The chair hears none. The amendment is adopted. The chair recognizes Mr. Leach to close on the amendment as amended.
Thank you, members. I move passage of the amendment.
Mr. Leach sends an amendment as amended. It is acceptable to the author's objection to the adoption of the amendment. Chair hears none. The amendment is adopted. Following amendment, the clerk read the amendment.
Amendment by Smithy.
The chair recognizes Mr. Smithy to explain the amendment.
Thank you, Mr. Speaker and members. We've been told throughout this process that the purpose of this bill is to make commercial truck and auto insurance more affordable and accessible. And so what this amendment does, it directs TDI to conduct a study and present the legislature with a report biennially every December prior to the session for the next 3 sessions after this. And that will tell us whether the legislation is having the desired effect or not. It will give us a picture of the impact that the legislation is having on the insurance market here in Texas. The amendment is acceptable to the author, and I would move adoption.
Mr. Smithy sends up an amendment. The amendment is acceptable to the author's objection to the adoption of the amendment. Chair hears none. The amendment is adopted. Does any member want to speak for, against, or on House Bill 19? The chair recognizes Mr. Leach to close on the bill.
Members, thanks again for your patience and your hard work on this bill. And with that, I move passage of House Bill 19.
The question occurs on passing the gross by HB19. All in favor say aye. Mr. Leach would like a record vote. The clerk will ring the bell. So Mr. Smith voting aye, Mr. Dean voting aye, Mr. Patty voting aye, so Mr. White voting aye. All members voting. There being 93 ayes, 52 nays, HB19 is passed in engrossment.